As we know, passing accounts themselves and the process of passing accounts is no science. It's a bit of an art, and we have people in the audience from all different walks of life, from the trust industry, from the accounting industry, from the legal community. And that's no surprise, and that really comes and stems in large part by virtue of the fact that we have to bring in various considerations in the process of the accounts. We today wanted to talk about some of the substantive and sort of what I would call the more meaty issues relating to passive accounts themselves, with a view to taking it to the next step if we can get this organized. This is that within the next few breakfast meetings, to take a real roll-up-your-sleeves analysis of passive accounts and walk through a mock set of accounts with a view to imparting some of these issues on top of that, sort of an overlay, a practical overlay. But for today, we thought it would be best to sit down and sort of cover off the topic areas. My paper is really, the opening paper, it's really just as an overview, talks a little bit about some of the classic areas, form of accounts, issues related to that, the jurisdiction of the court to pass accounts in the context of all varieties of fiduciaries passing accounts, such as the Decisions Act, and the Estates Act, and so forth. And then finally, I deal with some of the areas of complaint that are often seen in the context of passive accounts. The topics that we're going to have the other speakers, though, touch on are more of the practical and specific areas, talking about the dreaded receipts and disbursements of accounts and what that means and how they apply, compensation, and comment, review on that. Talking a little bit about capital encroachments. It's an issue that comes up in a great deal of these accounts. Investment accounts and the prudent investor rule, integrating the corporate information into the estate accounts, and then finally talking about documentary disclosure. So without further ado, I'd like to call upon Sean Graham, who's going to start off by hitting on what is, when I first got into passive accounts, a concept that I had to read and reread and Woodfield to make sure I understood. And today I'm still being told that I don't entirely understand it by judges, but receipts and disbursements. All right, Sean. I think there's some seats in the back too as well over the front.
Thanks, Ian. Thank you all for coming again. As Ian said, I'll be discussing receipts and disbursements. First, I'd like to briefly touch on the statement of original assets because it really sets the stage for everything in the accounts, and particularly the receipts section. As you know, the statement of original assets sets out each asset of the estate and its value at the date of death. It represents the estate as it was before the administration, and to my mind, it's really the first substantive section of any estate accounts. It provides a good deal of context for the entire administration, particularly the receipts section of the accounts. Hopefully, by the time the accounts are prepared, in most cases, the statement of original assets will no longer be contentious. Now, if a beneficiary is complaining and has complained about the outset about a low value ascribed to assets, or that certain assets were not realized by the estate trustee, for example, a disputed loan to one of the other beneficiaries, then that beneficiary is going to focus right in on the statement right off the bat, and that will form the basis of most of their objections. Once all the original assets are listed for the accounts, the way to tie it into the receipts is that each asset is cross-referenced to the receipts. So there will be a column normally on the right-hand side where the receipt number is referenced. So if an original asset is brought into the administration bit by bit, then there will be 3 or 4 or multiple entries showing that each time part of that original asset is realized. Obviously, if it's realized all at once, there's only going to be the one entry. That way you can trace through the original assets through the receipts section, and you can find out largely how quickly the administration began. So that leads me into the receipts and disbursements. Receipts and disbursements reflect the act of administration. Any asset or its proceeds, when the estate trustees start to administer it, will be a receipt, and then any asset or funds leaving the estate will be a disbursement. with an immediately distributable estate, you do not need capital and income or capital and revenue divisions. So you can have one receipts section and one disbursement section. I'll be focusing on the more usual estate. That's where there's an ongoing trust established under the will, or separate income and capital beneficiaries. In that case, you have four sections. You have your capital receipts, revenue receipts, capital disbursements, and revenue disbursements. Capital receipts reflect initial estate funds entering the administration. They include monies received on the realization of original assets, insurance proceeds, that's assuming the estate is the beneficiary, death benefits, refunds of monies paid by the deceased before death, principal portions of mortgage payments. And here it's important to note that if there's a mixed principal and interest components, you have to separate those out for the purposes of the revenue receipts and capital receipts. The principal, of course, is the capital receipt, and then the interest component is the revenue receipt. And then finally, there's personal property over which the estate trustees take control. In most cases, it's important to include values at the date of death, whereas at the date the estate trustees start to administer the property, which is usually very, very close to the date of death. Personal property, it's important not to gloss over that, in my view, in many estates, because often the personal property takes on, as you all know, can take on a greater role than its monetary value. So if it's left out of the accounts, even though it may not, from a monetary sense, play a large role in the administration, the beneficiaries can take that as a fairly sensitive issue, and it can cause problems that are otherwise unnecessary. Revenue receipts deal with income on estate assets. This includes income earned from unrealized original assets and executors' investments. Usually it's made up of interest, dividends, and rental income. Capital disbursements reflect monies paid out of the estate to satisfy requests, as well as initial debts, liabilities, and administration expenses of the estate. Some examples of capital disbursements are payments of funeral expenses, taxes paid on the terminal income tax return, and the professional fees, if any, incurred in preparing that return. Another example is payments of estate debts, appraisal and valuation expenses incurred to determine the value of the original assets, losses on the sale of original assets for the period from the time of death to the date of the sale, losses on sale of executors' investments, income tax paid on capital gains, solicitors' fees incurred in relation to the administering the estate, and distribution, of course, distributions of capital bequests. Revenue disbursements reflect distributions to income beneficiaries, as well as payments out of income, including income tax and fees incurred in preparing the tax returns, and that's subject to possible capital gains tax on sales of assets, which are capital disbursements. And finally, distributions to income beneficiaries. All receipt and disbursement entries have to include certain details. Obviously, the date of the transaction and the amount of money involved. For all receipts, the payer should be specified. If the entry reflects profit or realization, the relevant original asset or investment should be set out as well in enough detail for the reader of the accounts to understand it very quickly. For disbursements, obviously you need the payee, and if there's been a capital loss, you should reference the relevant original asset or investment as well. In terms of managing the process prior to the accounts, I would suggest, again, just about almost with any estate issue, the more disclosure ahead of time, the better. So, in an initial letter to the executors, we set out the assets as we know them, the debts and liabilities, and how the estate is going to be administered. I think most solicitors suggest that a similar letter should be sent to all the beneficiaries, And I think that letter, again, should be as detailed as possible. I think it should include a list of all the assets, all the debts and liabilities, and perhaps just as important, a request to the beneficiaries to fill in blanks. That will satisfy a number of initial issues. If there are no responses, you can probably take it that there won't be a lot of complaints about the initial framework of the administration. And as long as you meet that framework, then there are less likely to be complaints. I think the process can be taken one step further, and it is by most solicitors, I think. That is, when there's major events in the administration, in addition to your letter to the executor setting it out, you should send a draft or directly send a letter to the beneficiaries setting up the same things. Hopefully, when it comes time to pass the accounts, you have not only the accounts, but a series of letters that explain the major entries in the accounts. I think that will accomplish many goals. First, it provides genuine information exchange. And informed beneficiaries tend to be happy beneficiaries. If they're not happy, you're going to find out earlier. And you'll find out before you've paid out a significant portion of the estate. You can find out if it's a terrible problem, you can try to remove yourself early, let someone else administer the estate. If you have administered the estate, and the accounts are problematic, you've then got a record to give to the court that will color everything in the proceedings. And finally, tend to save fees. If the beneficiaries do give you the information you're asking for, you're going to need to spend a lot less effort getting it yourself. And finally, it controls the beneficiaries' expectations, which should never be underestimated in solving problems early on. Thanks very much.
Thanks, Ron. I appreciate that. Nothing like trying to manage expectations of beneficiaries is a lofty goal. Speaking of managing beneficiaries' expectations, compensation near and dear to my heart. It's the next topic we're going to deal with. We're very fortunate today, and I shall no doubt wish I hadn't announced this, but Anne Long, the true guru of passive accounts, is in the room from the Office of Children's Lawyer, and I always feel a little more nervous when we talk about this topic with her present, for a lot of reasons, because she does know so much about this area, but there's nothing like getting into a discussion with their office where you're acting for a lawyer, who's the executor. You're arguing over the lawyer's fees that he charged, legal fees. Then you're arguing over how much compensation he's entitled to. And then you're arguing over whether or not you're allowed to take compensation on the disbursement and the in and the out on the legal fees with the Office of Children's Lawyer. And needless to say, those debates tend to be fairly quickly dealt with by people like Anne Malone in a professional but practical way. And so I thought it'd be useful, although compensation is something that's talked about a lot, I thought it'd be useful to canvass the issue again and have Shell Eisen from our office talk about that and some recent developments. Shell?
Well, this actually, topic of compensation is the one that, at least in my experience so far, becomes the most interesting one to talk about when you're involved in administering the estate. Because inevitably, it's the subject of money. How much am I going to get paid? And that's almost automatically the first question that an estate trustee, when they come to your office, asks you, when do I get my 5%? And how do I get it? And can I get it? Can I get an advance on it? And is it true that I can actually get more than 5%? And if you don't get those issues sorted out right at the beginning, it just adds to what will end up being a nightmare at the end of the day. Particularly if you're talking about offices like the Office of the Children's Lawyer or the Public Guardian Trustee at the very end of it, when, as Ian says, we come to discuss these issues and they become quite controversial. The main thrust of it, I know that you have to impress on clients, and I'll go to the principles, but the main idea here is, in essence, what added value are you, as an estate trustee, giving to the estate? And that, at the end of the day, despite all the formulas, the 5%, the 2.5% you get on the money that comes into the estate, the 2.5% of the money you get going out is the main issue. And if you haven't added much value, or the worst scenarios where there's been a fraud or there's been mismanagement, you're not going to get the 5%, and in fact, you're going to get a lot less. The actual quantum of compensation is in Ontario, and in the most common law jurisdictions, is not actually set. It's Section 61 of the Trustee Act basically allows a court to allow fair and reasonable payment for the, I'll read the section, just be the care, pains, and trouble and time expended in administrating an estate. There's no formula, there's no tariff. It's, in essence, at the end of the day, if you're in the hands of a judge, what a judge thinks is reasonable based on, and there's a couple of cases. There's a seminal case in which the formula basically is a court will first look at the old tariff system, which is 2.5% of the money in, 2.5% of the money out, or 5%, and then go through, depending on how reasonable that is, the various factors that are involved. And there's a 1905 case that set out the factors, and basically they're common sense: the size of the trust, how much work was involved in it, skill and ability that's shown by the trustee, time occupied in performing the duties, and at the end of the day, the success of administrating it. The obvious question, though, is how is it that a court or a judge will come to an answer if you get to that point? You're at the mercy of a court if you get that far. There are some judges in Ontario who aren't particularly happy with trustees and executives and compensation. So the best thing to do is to make sure when you're advising an estate trustee he's got to keep good records. He's got to make sure that he's keeping everyone involved, letting the beneficiaries know what the status of the estate is. He has to make sure that he's preferably doing something. You can't just sit back and do nothing at the end and assume you're going to get your 5%. It just doesn't work that way. It also, in this unofficial tariff, we all know about the care and management fees. Trustees are also very interested in that. How is it that I get my extra 2/5 of 1%? What do I have to do for that? That's, again, not automatic. None of these things are. If you only get it if basically it's not an automatic distribution of an estate. If there's some work by a trustee in investing the money and looking after it over a period of years. And again, it's depending on the size of the estate and the amount of work involved, it's not an automatic thing. And again, you'll have to be able to substantiate what you did. The other issue that happens all the time, I'm sure we all get asked these questions, is by a trustee, is when can I get paid? I want to get paid right now. I've spent hours looking after all this, and there's $50,000 ready to be distributed. Can I take my money right now? The short answer is no, just to be really blunt. And that's one of the issues that, if in fact, at the end of the day, when we come to pass accounts, the judges take real exception to, or an executive will pre-take compensation. Without the consent of all of the beneficiaries, or anybody's got a financial interest in the estate, or by a court, you just can't take pre-take compensation. And to do so, well, in some cases, you get heavily criticized by a judge. You'll end up probably paying interest on the whole amount of money that you took, even though you may have been entitled to it at the end of the day. And it's just it's a red flag that infuriates various government institutions, and Ron will agree with that. It infuriates judges, so it's just a no-no, unless you have everybody's agreement. The other issue, one of the issues I want to talk about when it comes to compensation, are the things that judges look for when they want to reduce compensation, or when anybody wants to pay compensation. I mean, obviously, There's simple ways to do it, just by applying the 5% in, or 2.5% in, 2.5% out. But your clients and executives have to understand that they're only going to get work, they're only going to get compensation on added value. So, I mean, the best example, and one that happens all the time we see, is, for example, when the trustees make investments. And they make investments, they'll invest $100,000 over and over again, for example, on a bond. And you'll see, and I can't tell you how many times I see it, you see accounts where a trustee has taken his 2.5% on the, or whatever compensation he wants to take on the money that he's invested, the $100,000 over and over again, and not only on the interest or the income that he's managed to earn. And again, it's the old rule. What did you add? What did you add to the estate? If you haven't added anything, you're not going to get it. One other topic, a couple other topics I want to briefly touch upon. First of all, it's a simple one. It's the tax treatment of compensation. Professional state trustees are obligated to report compensation in their income tax returns. The question is, what's a professional estate trustee? Are lawyers professional estate trustees? What if you have a client who's done this 10 times in the last 5 years? Is he obligated to report the income? I can't give you the answer to it, but I can tell you that as a lawyer, and you want to make darn sure in any reporting letter that you send out to a client that they understand point blank that there is a tax liability if they are a professional trustee. And we say in our letters, reporting letters, whatever you do, see a professional, see your accountant, and make sure that you're not setting yourself up for a visit. The last topic I want to talk about, basically, is that at the end of the day, you just want to make sure that your executors understand that, as I said before, they have to make, if they haven't added value for what they've done, then all the various formulas, all the various points don't matter. It's what they've actually added at the end of the day when a court will give them money for. I want to thank you for listening.
We're going to turn now to Paul Trudell, who's going to talk about the investment accounts and the prudent investor rule. Paul?
That's okay. I'm here to speak about the investment accounts and the prudent investor rule. I'm beginning with investment accounts. Simply put, the investment account is a listing of the investment activity of the estate trustee. There'll be an entry for each of the investments purchased by the estate trustee and a corresponding entry for each investment redeemed by the estate trustee. Investment accounts do not reflect investments made by the deceased or realized by the estate trustee, but only those made by the estate trustee. The rules of civil procedure require a separate account to be kept where the estate trustee makes investments. The investment account must set out a separate account showing all money paid to purchase investment accounts and all monies received by way of repayment or redemption. And also keep a separate account showing the balance of all the investments that remain held by the estate. This separate accounting allows the reader of the account to see precisely what investments have been made by the estate trustee during his or her administration. More importantly, it also keeps these investments off of the accounts for the receipts and disbursements. Strictly speaking, actual investments or redemptions are not receipts or disbursements of the estate. The gains, losses, interest, or dividends will be considered receipts or disbursements as appropriate, but the actual investments are not. Because the investments are not shown on the receipts or disbursement accounts, compensation based on the usual percentages, as alluded to by Shale, is not charged on these investments. As noted by Justice Lane in the decision of Einstadt estate, there is no entitlement to compensation with respect to the disbursement of an investment, sale of an investment, until the investment actually leaves the estate. And only at that time is the compensation chargeable. Anything before that would be considered pre-taking. However, remuneration is chargeable by way of a care and management fee on those investments. But it's important to know that they're not shown as the receipts or disbursements of the estate, unless we have a separate account. As Shale alluded to, we can often see improper inclusion of investments in capital receipt accounts, and this tends to artificially increase the compensation trustees often claim. It's often very easy to see this when you look at the accounts and there's an estate worth approximately $1 million, and the capital receipts are in the several millions of dollars. Then you have a fair bit of churning and investment and reinvestment of those monies that improperly is captured on the capital account. That's improper. There should be a separate investment account that would reflect that. Turning to the prudent investor rule, trustee investments are restricted by terms of the trust and by legislation. In Ontario, we have the Trustee Act that enacts or encodes a prudent investor rule which authorizes investments in any property, subject, however, to a statutorily imposed standard of care. And what should we tell our clients then when they ask us what they can invest in? Well, I would tell them to invest in something that's absolutely safe, that also makes a ton of money. Something that's going to appreciate the capital significantly, all the while generating an excellent rate of return on investment. And if they can do that, they'll have no problems whatsoever. Short of that perfect investment, however, we should refer them to the provisions of the Trustee Act and take the client through those. As I said, the Trustee Act was amended in 1999 to codify the prudent investor rule. The amendments also removed a list of allowable investments and replaced it with the statutorily imposed standard of care. Section 27, sub 1 is the operative section of the Trustee Act, and it states, in investing trust property, a trustee must exercise the care, skill, diligence, and judgment that a prudent investor would exercise in making investments. It sounds easy, but it's not always easy to do in practice. As to the type of investment that's allowed under the Trustee Act authorizes investment in any form of property with the proviso that that type of property is something that a prudent investor might invest in. There's no longer a list of allowable transactions. In fact, with respect to allowable transactions, the Trustee Act amendments put an end to the issue of delegation in mutual funds. Previously, mutual funds were seen as an improper delegation of the investment authority of the trustee, were not permitted. The Trustee Act has been amended, though, and provides that any rule of law prohibiting a trustee from delegation of powers or duties does not prevent the trustee from investing in mutual funds, pooled funds, or segregated funds. So that expands the type of investment that a trustee might otherwise be able to invest in. In addition to setting out this general standard of care that a trustee must follow in planning investments, the Trustee Act imposes certain guidelines and sets out some criteria that must be considered by a trustee in investing in property. The Trustee Act requires that the trustee consider the general economic conditions, the possible effect of inflation or deflation, expected tax consequences, the role of each investment or course of action within the overall portfolio, the expected total return from income and appreciation of capital, and that refers to the even-handedness principle that Bianco will refer to, needs for liquidity, regularity of income, preservation or appreciation of capital, again that addresses the even-handedness principle, and the asset's special relationship or special value, if any, to the purposes of the trust or one or more of the beneficiaries, and that would allow a trustee to invest in something that's particularly near and dear to the hearts of the beneficiaries or permitted by the trust. The Trustee Act also mandates that the trustee consider diversification and not put everything into one investment. And diversification is actually required to the extent that it's appropriate to the requirements of the trust and general economic and investment market conditions. And again, I would expect that the size of the estate would dictate the extent to which diversification is required. The Trustee Act specifically provides that the trustee can obtain investment advice and provides that reliance on that advice is not a breach of trust by the trustee. again, if a prudent investor would rely on that advice under comparable circumstances. In a decision decided before the amendments, the court actually went on to suggest that it would be imprudent or improper for a trustee to not obtain advice in certain circumstances. In addition to obtaining advice, the trustee can also enter into agreements with an advisor with respect to delegating authority to invest. The trustee can obtain advice, rely on that advice if prudent, and also delegate functions. Delegation, however, must be carefully documented if there is going to be a delegation of investment authority. There must be a written plan or strategy that the trustee prepares and enters into. The agent must also agree in writing to follow the terms of the plan and comply with that plan. The benefit of having such a plan is that where there is a written plan and it's followed, a trustee is protected from liability for losses if the conduct of the trustee complied with the plan and the plan involved a reasonable assessment of risk and return, and again that a prudent investor would adopt that type of plan in comparable circumstances. It's that protection, I would suggest, that makes entering into such a strategy highly advisable. Once there is delegation of authority, there are certain things the trustee must do in addition to picking the right person and establishing a plan. They must monitor the acts of the agents carefully. With respect to any losses, if there is such a plan and it's reasonably prepared, there is protection to the trustee. If there's a breach of the plan by the agent may be found liable to either the trustee or the beneficiary in certain circumstances. Finally, just one last point, if there is a loss, the provisions of the Trustee Act now allows the court to look at the whole plan and not just the loss with respect to the one investment. That sets aside the court's prior reliance on the anti-netting provision, and the courts will take a more holistic approach in looking at the losses caused by that investment on the part of the trustee. Thank you.
Thank you, Paul. I appreciate your comments on the perfect investment rule. And it seems to me if we've got a written plan and from an appropriate financial advisor, you're going to go a long way to meeting that perfection that sometimes is expected. All right, bouncing back out of order, I apologize. I just read off the page wrong. It's Bianca Leneve, and she is going to speak on capital encroachments.
Good morning, everyone. I hope you can all see me. I did wear my flying shields. How are you? So I'm going to speak about capital encroachments in the context of trust arrangements set out in wills. Specifically, I'm going to speak about whether or not a trustee has the power to encroach upon capital, and then if so, what considerations a trustee must take into account in determining the amount or quantum of the encroachment. So the first step is to determine whether the will allows a trustee to encroach upon capital. Now, usually one looks to the specific wording of the will for the answer to this question. Typically in a will, a testator will set out a trust that provides that the income is to be paid for the benefit of a life tenant over their lifetime, and with the capital to be distributed to capital beneficiaries. And it's also typical in such arrangements to allow the trustee the power to encroach on the capital for the benefit of the life tenant. So the typical example is the case of the spousal trust, where the will sets up a trust for the benefit of the spouse, where the spouse can take from the income and usually the capital over his or her lifetime, and then any capital remaining is paid usually to children upon the death of the spouse. So if you look on page 1 of the article, we've set out a typical example of a spousal trust. To my said trustees, to pay to my wife, for the benefit of my said wife, such part or parts or the whole of the capital of the residue of my estate as, in their uncontrolled discretion, my said trustees consider advisable. Now, when you're interpreting the relevant provision in the will, You should advise your client, the trustee, to strive to give effect to the intentions of the testator. These intentions can be ascertained from the actual language of the will and extrinsic evidence surrounding the circumstances of the execution of the will. If the actual will or the capital encroachment provision, the wording is unclear, then you should bring an application for the advice and direction of the court to determine the extent of the trustee's power to encroach. So once you've determined that your trustee client does have the power to encroach upon capital, the next step is to determine the scope and extent of this power. Now, as can be seen from the example on page 1, normally a trustee is given uncontrolled discretion. And other ways this has been explained or set out is absolute discretion, unfettered discretion. Now, if only the story ended here. Unfortunately, although your trustee client may assume they have absolute, uncontrolled, unfettered discretion to encroach on capital, the courts have set out certain limits that have to be taken into account when deciding on the amount of encroachment. So I'm going to talk about two important limits. The first is the trustee's fiduciary duty to act impartially as between beneficiaries. And this is commonly referred to as the even hand principle. And Waters, in his textbook Law of Trust in Canada, sets out a neat description, and that is set out on page 2 of the article. Waters then goes on to describe the application of the principle in the context when you have two different classes of beneficiaries. So like in this case of the spousal trust, where you've got the spouse as an income and capital beneficiary, and then the children as capital beneficiaries. And that description is set out on pages 2 and 3. And basically Waters talks about the importance of maintaining an even balance between yield and risk. So as Paul talked about in his presentation, it's not easy to try to get the best yield possible for the benefit of the life tenant while also ensuring the growth of the trust fund for the benefit of the capital beneficiaries. So usually a trustee's fiduciary position will require her to maintain an even hand between the two classes of beneficiaries. Now, in certain cases, the trust provisions will specifically authorize a trustee to ignore the even-handed principle. And we can see that in the first example on page 1, where we see that the trustee is allowed to encroach on the capital for the benefit of the wife. And so here we see that the trust provision specifically authorizes partiality to the benefit of the wife at the expense of the children. Now, the second important limit set out by the courts arises out of the concept of malefides. I hope I'm pronouncing that right. This has been employed by the courts to limit trustees in their discretion to encroach upon capital. Now, the leading case is the House of Lords decision of Gisborne and Gisborne. This was not, strictly speaking, an encroachment case, but it did deal with the underlying issue of the scope of an executor's discretion. In Gisborne, the will established a trust fund for the care of the testator's wife, and the trustees were given the uncontrolled authority to in applying the trust fund for the benefit of the wife. Now, the wife in this case had her own property. She was eventually declared incapable. In 1877, they referred to her as a lunatic, but now we talk to her about being incapable, and she then required full-time care. So the wife and her representatives argued that she should be able to look to the trust fund for the majority of the source of funds for her care. And the trustee said, no, you should essentially exhaust your own funds first, and then we'll pay you the income and capital if necessary from the trust fund. Now, the House of Lords agreed with the trustees that they enjoyed an absolute discretion in how they applied the trust funds. Now, this was so long as they did not act with mana fides or bad faith. And the relevant quote is on page 4 of the article. The trustees' discretion and authority, always supposing that there is no mana fides with regard to his existence, is to be without any check or control from any superior tribunal. Now, the Gisborne decision was considered and affirmed by the Court of Appeal of Ontario in the Fox Estate decision. And as set out in the Fox Estate decision, the term malafides or bad faith can be broadly interpreted. The term is sufficiently broad to not just mean fraud on the part of the trustees, and it can be interpreted to also mean or capture acts by a trustee based on extraneous or irrelevant matters. So if the trustee has taken into account things that are irrelevant or unrelated to the intentions of the testator, this falls within the concept of bad faith. And an example of trustee action based on extraneous matters was found in Fox Estate. In this case, the mother was named as the estate trustee of her husband's estate, and she was given the discretion to encroach on capital for the benefit of her grandchildren, her son's children. And when her son married outside of the Jewish faith, she decided to give all of the assets to her grandchildren. And the court concluded that the mother had been motivated by her disapproval of her son's marriage, and this was an act of bad faith on her part. So the general rule appears to be that if the will provides for unfettered discretion to encroach upon capital, the courts will intervene in the exercise of such discretion if the trustee has displayed bad faith or malafides. Do I have time for one more? No. All right. Thank you very much.
Thank you, Bianca. I note that the term lunatic has vanished from the case law, but it seems to be bantered around my office the other day. We're going to now move on to integrating corporate information into estate accounts, and we have Elizabeth Holman to speak for that.
Thank you. As we've seen so far today, the whole purpose of estate accounting is to give the beneficiaries full disclosure. So they know what's in the estate, they know what's going out of the estate, they know if any losses have been made or any gains have been made. Paul spoke about the investment rule, and we note that the rules of civil procedure, which set out the items in the accounting, specifically says that you have to have a separate schedule for your investments. And that seems in keeping with the issue of full disclosure and transparency. What happens when we're dealing with an estate that owned in whole or in part a corporation? The rules don't mention it. They don't specifically say we need all of the internal transactions of the corporation. So what we're left with is all the executors have to do, all that they're required to do, is list the asset in the accounts. So if the testator owned 100 shares in X account, in X corporation, the accounts merely say 100 shares, X corporation. If there are any dividends, then the dividends are shown in the accounting. If the corporation is wound up, resulting in capital, then that's shown in the accounting. There is no separate schedule required for your corporate investments. However, we again know that we have to keep the beneficiaries happy, and to do that you have to keep them informed. So look at the situation that you're faced with. If you're faced with an estate that is mostly made up of corporate assets, you should do more full accounting with respect to those assets. So you may want to do a separate schedule that shows the internal workings of the corporation. If you have access to that information, you might want to put in the balance and loss information of the corporation as it goes along. Now, you may have a situation where you haven't put in the balance and loss sheet, but you still have corporate assets that are dealt with. The beneficiaries see that there are corporate assets, and they want more information. Do they have the right to demand more information on the internal workings of the company? And again, this is going to depend on many factors. First of all, is it an estate that the bulk of the estate are the corporate assets, or is it an estate where the estate just owned a few assets of a public corporation? Is it in a state where the executors are also the directors of the corporation, or are they merely put in the place of the testator and are shareholders? All of this information is going to depend upon what you, the trustee, want to disclose. We know the beneficiaries are entitled to backup voucher documentation. Can they go so far as to demand minutes of shareholders' meetings, profit and loss statements, financial statements? There aren't many cases on this point, but there are a few cases that might be of some help. The Irish decision of Shane and Nixon is a decision from 1976, and it was a case where, again, the trustees were not directors of the company, so they were merely in the position of shareholders. And the beneficiaries wanted more information. They wanted the internal workings of the company. The court decided that as the trustees have become the shareholders of the company, they're entitled to some information as shareholders, and they must turn that information over to the beneficiaries of the trust or of the estate. So in that instance, the minutes, the shareholders' meetings, the minutes of those meetings were turned over, as was the balance sheet with the profit and loss statements of the company. A more recent decision of Stewart, Hutchinson, and Spread, which is referred to as the Spread decision, was another scenario where the beneficiaries needed and wanted more information pertaining to the company. And the court again ordered that that disclosure be made. The court decided that the trustees were holding the shares in trust for the beneficiaries. The trustees were shareholders themselves and were entitled to certain information, and the beneficiaries would be entitled to compel those trustees to exercise their inspection rights within the corporation. So they were to exercise their inspection rights, and they were to provide the beneficiaries, again, with the minutes of the shareholders' meetings and all of the company's accounts. And the final decision is the Butt and Kelson decision. And in this scenario, the trustees were actually directors of the corporation that was owned by the estate. And when the beneficiary complained about the company's management, the directors refused to turn over the internal information. Now, when you have a trustee who is also an executor, this becomes a bit more tricky. A trustee or executor who is also the director of the company, things become a bit more tricky because the director not only owes a duty to his beneficiary, but also owes a duty to the company, to the corporation, and can't willy-nilly disclose information. So when you're in that scenario, you have to decide, is it going to harm the company in any way? Is it going to impede day-to-day operations? Am I giving information over to a beneficiary who maybe runs a competing business? What are the facts that I'm faced with? And the court, in this instance, they refused to give information over to the beneficiaries. And the beneficiary went to the court, and the court determined that the beneficiaries themselves were entitled to be treated as though they were shareholders of a private company controlled by the estate. And as shareholders, they would be able to compel a voting, to possibly rework the articles that would allow them to get this extra information that they wanted from the directors. So the court said in order to circumvent that whole proceeding, we will order that internal information pertaining to the company be produced. But it will only be, the information will only be produced where the documents sought were properly identified, the beneficiary established a proper case for seeing them, and also agreed not to disclose the information to anyone other than his legal advisor. The court also determined that objections from the company, the other directors themselves, or from the other beneficiaries could be taken into account. And it left open the issue of whether other shareholders in the corporation could object to the disclosure. So it seems that the courts are, again, continuing the trend of full disclosure, as much disclosure as possible, to the beneficiaries, and this is now moving into the corporate disclosure information. Again, the rules don't require you to do any special spreadsheet or any special schedule, but keep in mind your situation. Is it an estate that's mostly made up of this corporation? Or does the estate just own a few shares? If it's made up wholly of the corporation, disclose as much as you possibly can. If you need extra information, because perhaps you're a director and you have access to it, you can always go to the court to apply for that information. Thank you.
Thank you, Ms. Smith. Well, we're just coming up to our last speaker, David Smith, who's going to talk about documentary disclosure and production of vouchers in the context of the passive accounts. And I hope what we've tried to do today, when we all sat down and put together this program, was touch on two important themes. One is work through some of the central and core issues of a passive accounts, and secondly, to deal with what, as our firm sort of perceives the passive accounts, is really all about, and not just is an exchange of information. And I think we get caught up in the numbers and the presentation not being in written format. But underlying all of the passive accounts process is really an expectation of the courts, beneficiaries, and the like in the process to exchange information in a meaningful way. So without further ado, and effort not to get lost in the numbers, we're going to ask David just to wind up his comments on this area. Thank you.
Good morning, everybody. So my topic is just really touches on, to some extent, what everybody else has talked on, in the sense that what we're talking about in the whole accounting process is really crystallizing in a really intense way the relationship between the executor and the beneficiaries. And so there's really three themes that I want to touch on. The first is substance versus form. The second is proof versus explanation. And the third is the judge as the audience. We're obviously dealing today a lot with the format of accounts on a pass-through accounts. If we have an amicable situation between executors and beneficiaries, it's often tempting to try and resolve the matter of accounting to the beneficiaries by providing them with an informal set of accounts. Because at the heart of it, the beneficiaries really want to see what's backing up the accounts. And so more often than not, the backup documentation or the vouchers are arguably more important than the form of the accounts. Because inevitably, in a contentious situation, the beneficiaries will insist on looking at all of the vouchers, insist on looking at all of the backup documentation. So I think the first point, and certainly we've all encountered this in our practice, is an organized client is the best kind of client to have. If you have a client who's organized all of the invoices, canceled checks, bank statements, what have you, it's going to be a lot easier to then account to the beneficiaries and back up the accounting, particularly with, one's tempted to call them difficult beneficiaries, but at the same time, beneficiaries are entitled to know where's the canceled check, where's the proof of payment. We've all encountered this in our practice. So having that documentation is key. My second theme, which is proof and explanation, I think it's important to focus on the difference between proving your accounts and explaining your accounts. As litigation lawyers, we're always thinking of a contentious situation. We know we're not really in the real world. We're in a sort of abstract world where every estate is contentious. But it's helpful for us in terms of looking at situations. From the very first time the executor walks into your office, think about how you're going to justify his or her actions to a judge. And so if that's the standard that you're keeping in the back of your mind at all times, I think the duty of the executor and the backup documentation is going to be that much better. And when I talk about explanation, I'm thinking here not simply proving that you spent $2,000 on a lawyer for an opinion on a slip and fall on the estate residence, for example, but rather, why did you seek that opinion? And if the lawyer recommended starting a statement of claim, you're able to explain to the beneficiaries, look, not only did I incur this disbursement, I incurred it for a very good reason. I was trying to protect you as the beneficiaries. So I think always thinking about explanation rather than merely proof takes us one step beyond the sort of bland duty to account. And again, it's going to impress a judge on a passing of accounts if you can satisfy that judge that you were so concerned about the beneficiaries that you explained to them along the way. You gave them a disclosure of opinions obtained or what have you. And so it's going to serve you in good stead. And again, we always want to think, hopefully it's not going to happen, we always want to think ahead to the day when we're in front of a judge on a contested court audit. How can we best sell the actions of the executor? And so that's my third theme, which is touching on the sort of threshold that you keep in mind in terms of what duty of care do you demonstrate. You could argue it should be enough to simply say that the executor should look out for the best interests of the beneficiaries. I think if you say to your client, look, you've got to be able to demonstrate this to a judge, it's going to sort of ratchet up the due diligence on the part of the executor that much more. Last point I want to touch on briefly is legally the beneficiaries have what's called a joint proprietary interest in any documentation that the executor has, subject only to privileged documentation. I think if we think about the beneficiaries as literally having an ownership interest in everything that you've got from a legal point of view, that's going to help the client. You explain to them, look, the beneficiary has every right to see the documentation backing this up. And if push comes to shove, the judge is probably going to err on the side of favoring disclosure to the beneficiaries. As Liz mentioned, that's the general trend. I think probably that wraps up my comments. I have a couple of cases I've referenced in my paper. One point I wanted to mention in my paper, at the top of the second page, it should be falsification, not forfeiture. Please change that in your paper. I appreciate it. Thank you very much.
Thank you, David. And I think your comments on facing a judge and a contested audit are apropos. Although our firm loves to be given the opportunity, it is the last thing any client, beneficiary, or executor wants to see. If you want to see an unhappy judge, there are very few cases that would meet the top of the list of judges who don't do this kind of work regularly, and they get slapped with a 3 or 4 day passive accounts trial. You're not looking at a happy individual, so that's not going to help the process either. Anyway, I hope this has been helpful. We're going to, as I say, follow this up with another Part B in the next short while to walk through a tangible set of accounts and apply some of these concepts directly. So we look forward to seeing you again if you think it's necessary, and thank you for coming tonight.
Well done.